Now, in a significant and rare move, President of India, Srimati Droupadi Murmu, has invoked Article 143 of the Constitution, seeking the Supreme Court's opinion on a recent ruling concerning the timelines for granting assent to bills. Article 143(1) allows the President to refer matters of legal and public importance to the Supreme Court for its advisory opinion. This move comes after the top court's ruling, which set strict timelines within which the President and governors must grant assent to bills passed by state legislatures and parliament, and President Murmu has sent 14 pointed questions to the apex court for its opinion, while emphasizing that Articles 200 and 201 of the Constitution, which govern the process of assent to bills by governors and the President, do not prescribe any deadlines or specific procedural requirements. Now, the centre has called it clear overreach and has demanded constitutional bench to resolve this entire issue. Now, remember, this comes a month after the Supreme Court's landmark verdict in the Tamil Nadu case. Ananya Bhatnagar joins me with more inputs. Ananya, to simplify for a better understanding of our viewers, take us through those pointed questions that have been sent by President Murmu.
Well, definitely, the whole Tamil Nadu governor issue, which had reached the Supreme Court, which was heard for a long time, and the Supreme Court went on to, exercise its extraordinary powers under Article 142 of the Constitution of India, has been, given a counter by, in fact, the President of India, wherein she has actually used her special powers under 143. And has gone on to, ask 14 pointed questions to, in fact, the Supreme Court of India over its judgment in the Tamil Nadu governor's case, and very categorically has asked that when Article 200 and 201 do not stipulate a timeline as per the Constitution of India, then how could the Supreme Court actually do that? Is it, a use of plenary powers of the Supreme Court by the states against the centre, is what the President has gone on to say. The President has also asked how can the President be given a particular timeline when the Constitution does not stipulate the same? The centre, on the other hand, has asked for a Constitution bench to hear this particular matter. But Akansha, the twists and turns in this matter have taken place a lot, because the Supreme Court also, while penning down its judgment, its 419-page judgment, had used its power under Article 142, which is an extraordinary power of the Supreme Court, in order to do complete justice, wherein it set timelines not only for the governor but also for the President of India, and that is something that was not finding way with a lot of legal luminaries and in fact former judges or legal minds as well. And now the President of India, the centre, could have adopted a route wherein it could have filed a review petition, but the main concern I think that could have been there with the central government's lawyer is that the review petition goes before the same bench, right, and it is heard inside the chamber, so it might not have served the purpose. But now what has happened is that very categorically the President of India has pointed 14 strong questions to the Supreme Court of India.
Right, and since you mentioned those 14 strong questions, going to request you, Ananya, please continue to stay with us. Let me take our viewers through those 14 very important questions. The first and foremost question is, what are the constitutional choices that are available to a governor under Article 200 upon receiving a bill? Is the governor required to act solely on the advice of ministers when dealing with such bills is another question. The third is that can the governor's discretion under Article 200 be subject to judicial scrutiny? The fourth being, does the Article 361 even completely shield a governor's decision under Article 200 from court review? Fifth is, in the absence of an express timeline in the Constitution, can the judiciary even impose time limits on governor for acting on bills? Also, can the President's discretion under Article 201 be judicially reviewed? Seventh being, is the President bound by judicially prescribed timelines in the absence of constitutional mandates? Eighth, must the President necessarily seek the Supreme Court's opinion under Article 143 when a bill is reserved by a governor? Can courts intervene in decisions by the governor or President before a bill becomes a law? That's also an equally important question. 10th being, is it even permissible under Article 142 to override or substitute decisions of the President or even the governor? The 11th being, does a bill passed by a state legislature become law without gubernatorial assent, which is the governor's assent? Now, should constitutional interpretation questions first be referred to a constitution bench under Article 145(3), Also, does Article 142 extend beyond procedural matters to allow rulings that contradict existing laws or constitutional provisions? 14th and the last question, can center-state disputes be resolved outside Article 131, which provides for exclusive Supreme Court jurisdiction? I go back to Ananya, who continues to stay with us. So, Ananya, the moot question being, can in fact there be timelines imposed by the Supreme Court? And of course, the overreach of the judiciary is now back in the spotlight.
Well, definitely it's back in the spotlight, but before I take you through what's more poignant, but I'll take you through what the timeline of this has been. You know, this reference from the president comes hours after the new Chief Justice of India, Justice Justice B.R. Gawai, actually took over as the 52nd Chief Justice of India, and hours after his taking oath and assuming the office. This reference has come in. This is the first hurdle for Justice B.R. Gawai, who has to address this. He might constitute a bench to actually answer these questions. And as President has pointed out and has suggested, there can be a constitution bench that can actually deal with that particular point. But out of those 14 questions, two major questions that arise out of the reference that has been sent by the President of India to, in fact, the Supreme Court exercising its its special powers under Article 143 is that whether the Article 200 and 201, when it does not stipulate a timeline, how can the Supreme Court actually go ahead and stipulate a timeline for the President of India and the governors? Secondly, can the 142 powers be used to stipulate or substitute the powers that the governor or the president has? And third and most important one, can the president be directed under, by use of this extraordinary power of the Supreme Court to actually set up a timeline for the president itself? So, tough questions being asked. Who will answer these is something that would be very, very interesting to see, because the matter is with the Chief Justice of India. He is to make this reference to a particular bench, or would he hear it himself is something that we'll have to wait and watch for. But definitely, it's a big move coming in as far as, the structure of the democracy is concerned, the basic structure of democracy is concerned, because even Keshwananda Bharati judgment has, passed a test of the Supreme Court, and now we'll have to wait and watch as to how things pan out as far as these timelines for the governors and the president is concerned.
Sure. When you say we'll have to wait and watch, take us through the procedure. Now that the president has sent those critical questions, we know that there's been a change of guard as far as the CJI is also concerned. What's going to happen next?
Well, the Chief Justice of India, the ball is now in the court of the Chief Justice of India. He might give out his opinion by himself. He could constitute a bench to actually address these questions, or he can simply say no and refuse to give any kind of a response to it. However, the last option remains to be a very, very bleaky one. It might not be adopted. There would be some kind of a reference that could be sent back to the President of India, or a bench could be constituted to actually hear upon these questions. And whether the most important question that needs to be addressed is whether the 142 power, the extraordinary power of the Supreme Court to do complete justice, could come in way, could actually create a timeline for the president or the governor, or could it substitute what is there stipulated for the president and the governors under Article 200 and 201 is something that the Supreme Court needs to answer back now itself.